Welcome to our free 1-hour CLE representing divorce injury clients and how suing an abusive spouse can improve divorce results. This free CLE is sponsored by divorceinjury.com. Well, hello. My name is Keith Perkins. I've been practicing law for almost 30 years. Most of my time has been representing victims of domestic torts. I've won almost $300 million in domestic torts judgments. I've taught these legal principles to law schools and legal conferences throughout the nation. I'm the author of the book, Domestic Torts, Representing Divorce Injury Clients, that is published by Thomson Reuters, and I've devoted my legal career to helping victims of crime and to helping the lawyers who serve them. And so today we'll be discussing three key questions. One, what are domestic torts, or otherwise known as domestic tort divorce injury claims? Two, why haven't I heard more about them before? And three, why is it critical that I learn about them now? We'll also be discussing ethical responsibilities and how you may be committing legal malpractice right now without even knowing it. And finally, we'll introduce to you some exciting new tools and resources that can greatly help you in your law practice. So first, what are domestic torts? Well, domestic torts are an overlapping combination between three different areas of law: tort law, criminal law, and family law. More specifically, a domestic tort is a personal injury claim that arises from the criminal or the intentional misconduct within a domestic relationship. So domestic torts include such things as domestic violence, sexual assault, date rape, child abuse and molestation, video voyeurism, revenge porn, fraud, including paternity fraud, alienation of affection, seduction, sexually transmitted diseases, invasion of privacy, interference in family relationships, elder abuse, conversion, destruction of property, murder, and many other matters as well. Now, some of the terms that we're going to be using are kind of technical legal terms that are used by lawyers, such as tort and domestic relationships. But those terms really aren't the terms that are used in our everyday language, nor are they the terms with which the public are generally familiar. So if we put the term domestic torts into terminology of what most people would be familiar with, you can call it a divorce injury. So throughout this presentation, when we're talking about domestic torts or divorce injury, we're really talking about the same thing. Now, why haven't I heard more about domestic torts before? Well, we'll have to really go back in time, back to the late 1800s. In the late 1800s, women were actually legally viewed as the property of their spouses, or their husbands, fathers, or employers. And so an injury to a woman actually created a legal right for the husband, who could sue for his loss of property. The woman herself had no legal right to sue for her own injuries. Now, I want to show you a powerful example of this from a movie called The Unforgiven.
No, please.
Hold the bitch, Dave. Go on, hold her. Hold her, damn it, Dave. Mike, don't get it. You think it's funny?
Get away!
Get off of her, cowboy. She gonna die?
She's gonna live. She didn't steal nothing. Or just give a giggle, that's all. She didn't know no better. Gonna hang him, little Bill.
Bye.
Step over to the office and get the bullwhip.
A whipping? That's all they get after what they've done?
Whipping ain't no little thing, Alice.
But what they've done, they can talk
Alice!
about more than...
Shut up! Little Bill, whipping ain't gonna settle this.
No?
This here's a lawful contract between me and Delilah Fitzgerald to cut whore. I brought her clear from Boston, paid her expenses and all, and I got a contract that represents an investment of capital.
Property.
Damaged property.
You boys off the bar T. You got your own string of ponies?
Yeah, I got 4. 6.
Guess you just soon not have a trial, no fuss, huh?
No, sir.
All right. You did the cutting. Come to thaw, you bring in 5 ponies and you give them over to Skinny here.
5.
And you bring in 2. You give them over, you hear?
Yes, sir.
It's a bullwhip, Bill. Maybe we don't need this whip now.
You ain't even gonna whip them?
Well, I find them instead, Alice.
For what they've done? Skinny, get some ponies, and that's it? That ain't fair, little Bill. That ain't fair.
Hell, Alice. It ain't like they was tramps or loafers or bad men. You know, they were just hard-working boys that was foolish.
Alice? And Delilah?
Go ahead.
Yeah, that's the way the laws were. Women were considered as property of men. And women did not have their own legal rights. And then, somewhere along in the late 1800s, the beginning of the women's rights movements proposed something new called the Married Women's Properties Act. And as a result, individual states began to enact laws and statutes that for the first time recognized women as their own legal separate person. These laws permitted women to own property in their own name, work for and receive their own salary, write their own wills, sign contracts, and importantly, sue for damages to their own property. However, change came very slowly and in piecemeal fashion. Now, the year 1910 was a time of tremendous change in the United States. So why are we talking about 1910? Well, 1910 was 9 years before the 19th Amendment gave women the right to vote, and it was in 1910 that the United States Supreme Court had the very first domestic violence case of Thompson v. Thompson. That case, for the first time, raised the question of whether or not a wife had the legal right to sue her husband for intentional injuries arising from his brutal, intentional assault upon her. Now, at the time, the Chief Justice of the Supreme Court, Melvin Fuller, had just died prior to the hearing of this case, and a second justice, William Henry Moody, was really sick and he was about to die, so he didn't get to participate either. So this case of first impression was heard and deliberated by a depleted U.S. Supreme Court of only 7 justices, and of course all men. This decision came down on a sharply divided court on a very narrow majority of only 4 justices, which ruled that a wife could not sue her husband for physical injuries even though what he had done to her was a crime. The majority rationalized their ruling as they feared the possible evils of permitting a wife to sue her husband for injuries would open the doors of the courts to accusations of all sorts of one spouse against another and would bring into the public notice complaints for assault, slander, and libel, and alleged injuries. Therefore, the U.S. Supreme Court majority concluded that it did not believe that the new Married Women's Property Acts were intended to revolutionize the laws governing the relationship of husband and wife between themselves. Consequently, the majority ruled that a wife could not sue her husband for injuries caused by his intentional crimes upon her. And finally, the majority of the Supreme Court rationalized that a spouse did not need the right to sue for damages because they were already given sufficient alternative relief for such atrocious wrongs, as they may resort to the criminal courts or they could get a divorce. Now, I want you to remember this argument as we'll come back to it later. However, there were 3 justices that wrote a powerful dissenting opinion. Justice Charles Evan Hughes and John Marshall Harlan were known as civil rights advocates and champions, and Justice Oliver Wendell Holmes would become a future Chief Justice of the Supreme Court. All of them together wrote a very powerful dissent, and they argued that under the construction that was held by the majority, the court is put in the anomalous position of allowing a married woman to be able to sue her husband for the recovery of her property, but denying her the right to sue him for damages arising from his brutal assault upon her person. We will not assume that Congress intended to bring about any such result. We cannot believe that it intended to permit a wife to sue the husband for damages to her property and at the same time deny her the right to sue for injuries committed against her person. And yet, that is exactly what the 1910 case of Thompson v. Thompson did. And unfortunately, every state in the United States nearly followed the U.S. Supreme Court's case of Thompson v. Thompson to prohibit all domestic torts which denied women the legal right to sue their abusive spouse for criminal assault. And this continued and held sway for the better part of the past century for almost 100 years. It took nearly 100 years for the effects of Thompson v. Thompson to be overturned. Now, this chart shows every state in the nation and how long it took for each state to finally overturn it. And you can see it wasn't until the 1980s that a majority of states had overturned Thompson, allowing the right for women to sue their abusive spouse. And the last state didn't overturn it until 2003. Now, every state in the nation does support domestic tort lawsuits by victims. However, it has left almost 100 years of negative nuances. Now, during that same period of time, the practice of law itself has changed from lawyers as general practitioners, in which one lawyer did all types of law, including criminal defense, contracts, wills, trust, evictions, litigation, divorce, and injury claims, to attorneys who practice separate and focused areas of law. Now, you have your divorce family law attorneys and personal injury law attorneys. And as a result, this has caused a divide with some gaps in what legal services are currently being offered. So the question really is, who is representing divorce injury victims now? On the one side, you've got your divorce attorneys representing nearly 1 million divorces a year. On the other side, you have your personal injury attorneys, but they're primarily focused only on accidents, and that's only if there's insurance coverage involved in those accidents. So customarily, personal injury attorneys are not incorporating into their practice intentional torts. And divorce injury claims are all based in intentional torts. So who is representing the divorce injury victims? The family law attorneys are pointing to the personal injury attorneys saying that's their job. Personal injury attorneys are saying, well, we don't do that. It's the divorce attorney's job. In the meantime, there are nearly 4 million incidents of domestic violence every year. So it's been extremely difficult for divorce injury victims to find a lawyer who's willing to help them in their divorce case. Now, in the meantime, what is it like for these victims of domestic violence? What are they experiencing? I want to share with you what to me has been one of the most influential and powerful things that I've ever witnessed, and to really help us understand the trauma that divorce injury victims have suffered. I do want to give you a bit of a warning. This little 4-minute video clip is of a real-life recorded incident of domestic violence. narrated by its victim.
He was a member of our congregation. And because of that, I had a great deal of trust that he was a really good person. But, you know, he lived a double life.
Hi, Marlon. Brian with a 911 patch for you. I've got an open line with a domestic in progress. In progress? Yeah.
Ironically, he said from day one of the marriage that we had to have rules, and the rule was no hitting. I don't have a problem with that. I don't know why he's making a point of it.
But you can hear him fighting in the background. You hear him? Yeah. You hear him?
He said, you better shut up or it's going to be lights out. And he hit me again. He threw me around the room. My head was hitting the walls, hit the side of the tub. He threw me down. My head was bouncing on the hard floor. There was all this bruising that ran from my injuries down into my face, under the skin. I had a black eye, I was swollen, it ran down around my mouth and half of my nose. And now he's got a gun. Kneels down and he's got one knee like on my thigh and he's got this gun. So he gets the end of the barrel in my left eye. He's pressing it against my eye. He took up one bullet and he made me hold it in his hand. He said, think about how this is going to feel when it goes through your brain. I was convinced that he was going to kill me. I tried to cooperate with him as much as possible, to be submissive, obedient, be the wife he wanted me to be. It was my whole life, you know, I was like broken. Not just physically, you know, mentally, emotionally, I was lost. Trying to figure out, is this real? What's going on? This is the man that I love.
It's important that we remember the trauma and the horror that victims actually experience. And it's also important that when we're trying to help victims of domestic violence from a legal perspective, that we need to remember some of the legal basics that are too often forgotten. So for just a moment, I want to go back to law school. So sometimes we think that if we get this victim down to the court, that the judge can help her. Well, the answer is yes and no. We have to remember that the court really has 3 different doors or legal systems of which we need to be aware and remember: the criminal system, the civil system, and the family court system. Now, each one of these doors has different powers and remedies and goals. So we first need to understand what is it that the victim needs, And then we need to be able to go to the right door or the right series of doors to get it, and perhaps even stack the remedies together. Now, the victims themselves will often be facing a dilemma. For example, assume for a moment that the criminal system actually works and the bad guy is criminally convicted, say for something like assault and battery. However, if the victim is only in the family court system, the divorce judge is going to look at that victim and say, okay, you're here in the family court system. I am going to equitably divide the marital property without regard to marital misconduct. And then the victims risk losing half of the property in their divorce. And if they don't obey it, or if they refuse, they could be held in contempt of court. Now, does the victim feel like they've had a sense of justice? No, they won't. He gets criminally convicted and he just walks away with half of everything. Nothing really happened to him. He gets away with it again. Isn't that just like the feeling that is reminiscent back to how the victims felt in the 1910 case of Thompson v. Thompson? Remember, the majority ruled that we do not need to give victims the right to sue because they've got enough remedies already. The bad guy might be criminally convicted under the criminal system, or they can have the right to get a divorce. Isn't that enough? Well, the answer is a resounding no, because they're missing entirely door number 2. And door number 2 remedies can be critically important for a victim of domestic tort. Now, if you are successfully incorporating the all 3 of these doors together for a victim of crime, it might look something like this. When possible, establish liability under the criminal system. Even if it's not possible, you can still at least use the civil system for the establishment of injuries and establish her damages with a civil judgment. Now, that judgment becomes a debt. It is a debt that he owes to her. Then you get to use the family court system to collect the debt. It's here in the family court system that the abuser can be forced to pay the debt that's already been established in the civil system. So in this way, it preserves the family court mandate not to consider marital misconduct. Doesn't have to, because the civil court system has already done that. Now, in a typical divorce, a divorce judge will try to equitably divide the property, with each spouse getting roughly half of the property. But if we're dealing with a divorce injury case, he now owes her a debt for causing her injuries. The family court system can force the abuser to pay the debt off by offsetting to her from his half of property that otherwise he would normally walk away with. And so it could look something like this. In this way, he has to pay his debt back over to her, and it can dramatically increase the amount of property that a divorce injury victim receives in the divorce. So simply stated, use the family court as collections. So let me show you an example of how this can work from the woman that we just heard from a moment ago. Here is the rest of her story.
12 stands for local news. And now, from Arizona's most watched station, this is 12 News at 5.
This Arizona woman was beaten by her husband but refused to give up. Learn how she fought to get her life back.
These next pictures are hard to look at. A wife brutally beaten, nearly killed by her husband. But instead of being a victim, Patty Lumpkins made her abuser pay. She took her husband to civil court, winning a historic $1.2 million judgment, one of the largest domestic violence settlements ever in Arizona. And it's a case that many hope will help other abused women. Kathleen Mascarenas joins us with more on Patty Lumpkins' story.
Well, Lynn Sue, when you hear that Patty Lumpkins won a $1.2 million settlement, you have to hear the rest of the story. Now, when she married Jeff Lumpkins, she came for money he did not. During the marriage, he physically abused her and nearly murdered her. And during the divorce, he stood to gain half of her estate. Now, Patty wasn't about to let her abuser get one last shot at her.
Once I recovered from one blow, then he was after me again. And
it's a fight that started over disciplining Patty Lumpkins' daughter.
After he tried to drown me, then he picked me up again, and he did the same thing again to me.
As Patty begged for her life, her husband Jeff forced her to hold a bullet in her hand. He then loaded the bullet into the gun and pointed it at his wife's battered head. The 911 call recorded everything. 45-year-old Jeff Lumpkins is now serving a prison sentence for aggravated assault. But last week, he was face-to-face with his victim in civil court. This time, his wife was going after him with a lawsuit. After a 4-day trial, Patty won. The jury gave her a $1.2 million settlement. Realistically, she'll never see a penny, but it does keep her husband from splitting her money in a divorce.
And it was a big, fat figure that creates precedence now that, yes, violent people can get sued for $1.25 million.
2.5 years after nearly dying, Patty's learning to live again and finally feels she's gotten justice.
I know now that I'm free.
In Phoenix, Kathleen Mascareñas, 12 News.
So until the mid-1990s, there were very few domestic tort judgments, and most of them were very small, like $6,000, $9,000, $15,000. However, since the mid-1990s, there have been many more domestic torts judgments, and many of them over $100,000, even $1 million or more. So why are domestic torts judgments so big? Well, you have to remember in comparison that most standard personal injury lawsuits like car accidents are focusing on compensatory damages only, damages to compensate people for the injuries that they've suffered. Now, this can include injuries such as past and future medical expenses, past and future economic losses, and past and future pain and suffering. However, in divorce injury cases, you also get to claim punitive damages. Why? Because punitive damages are additional damages designed to punish and deter evil-minded conduct. And that is exactly what we're talking about here in divorce injury claims. And so, in addition to the compensatory damages, the additional questions need to be addressed. What is it going to take to financially punish this man? How much money does he have? It becomes relevant if he's wealthy, and in a punitive damage case, his wealth works against him. The court gets to consider, all right, we want to know how much money he's got because we need to know how much we have to hit him in order to punish him. Now, punitive damages are also meant to deter other people. We want to make sure that other idiots out there do not do the same thing that this guy has done. We want to send a message out there into society that is going to be strong enough to deter the other guys. We want the other guys to say, oh my gosh, did you see what happened to this guy? We do not want to be like that guy. We do not want to do that conduct. Now, sometimes men are not afraid of going to jail, but most guys are afraid of losing everything in their wallet. And that's what punitive damages are for. So in the divorce injury world, you get both the compensatory damages and the punitive damages. So let me bring this back again to that lady we talked about that obtained that $1.2 million judgment a moment ago. In her case, the medical bills for her injuries were only $2,000. She got beat up, had cuts, and had to go to the hospital for 1 day, and she had just about $2,000 in medical bills. Now, by comparison, if you go talk to a typical car crash injury attorney, most of the time they were going to tell you that you get to take the medical bills and multiply it by 3, and there's your pain and suffering. So you're talking about a grand total of about a $6,000 claim for your medical bills and pain and suffering. But when we're talking about divorce injury cases, that's not how it's calculated. This jury came back with a $200,000 compensatory judgment for her pain and suffering for the trauma and the horror that he put her through. That is 100 times the amount of her medical bills. But they still weren't done. The jury considered what additional punitive damages do we have to find to financially punish this man and to send a message out into our community so that no other idiots out there do this. And so the jury returned an additional $1 million punitive damage judgment. So the total amount ended up being over $1.2 million judgment. That's why divorce injury judgments are so big. So over the past 30 years, I've been working on divorce injury claims and divorce domestic tort claims. And you're going to be able to find many times that the victims are entitled to and in need of legal remedies beyond what the criminal system can give, and that are only available through the civil system. You cannot jump over and miss door number 2. You need to include it. So divorce injury claims often produce extremely large, sometimes multi-million-dollar civil judgments. They can also create high leverage pressure that can be powerful and an effective weapon in successful negotiations and settlements of the victim's claims. Domestic tort judgments can affect distribution of property in divorces, garnishment of an abuser's wages, retirement distributions, custody of children. Yes, I've actually seen that. Termination of parental rights, and yes, I've seen that too. Distribution of life insurance or estate proceeds, and expected inheritances. Domestic torts judgments can be a financial life sentence that has the potential to follow the abuser to either eventual prosperity or to their grave. Even if nothing is ever collected, for many victims, it's truly not about the money. It's about therapeutic jurisprudence or using the law to hold the perpetrator personally accountable to them. So, why is it critical that I learn about domestic torts now? Well, simply stated, we are in a different world. We're in a world today where women do have a voice, and it's loud and it is clear. And they want to hold the perpetrators personally accountable to them. And they are banding together, and they're wanting to make sure that there is a change. This is what the entire Me Too movement is based on. And domestic torts can be a huge part of the answer for them. So this might be the most important part of the entire presentation that I want you to be aware of, and I want you to walk away with. What percent of U.S. divorces include domestic violence as a major factor for women? What do you think? You've probably handled several divorces, probably represented many women. What percent of those cases do you think that women would say domestic violence was a major factor? The answer is 42 to 44%. That is staggering. It's astonishing. So how do we know this? Well, we know this because of 2 major research studies. One was a national study that was done over 1,500 women who had been divorced, and 42% of the ex-wives gave domestic violence as a major factor in causing their divorce. Now, domestic violence ranked 8th among ex-wives as a major reason for causing their divorce. It was the 8th most frequent common reason for causing a divorce. Domestic violence ended up being more common as a reason given by women for why they got their divorce than was financial problems. So now that this national study closely replicated a prior study from Oklahoma in which it conducted a survey and found that about 44% of women responded that domestic violence was a major reason in their divorce. So we have 2 major studies between 42 and 44%, given that women have gone through, will say that domestic violence was a major factor in causing their divorce. So when we are thinking ethically about how we should be practicing law, we need to be remembering this 42% of women that say that domestic violence is a major factor in causing their divorce. So how does that impact the practice of divorce attorneys? Well, the studies will predict that on average, 4 out of 10 of your female divorce clients will say, if they were asked, that domestic violence is a major factor in causing their divorce. 42%, 4 out of 10 of your divorce women divorce clients will say that domestic violence is a major factor in causing their divorce. So, are you asking your clients the right questions? And are you providing your clients the right legal services? Now, when we think of domestic violence injuries, sometimes we may assume that our clients are going to look like this. We're going to be able to look at her and think to ourselves, oh wow, yeah, I can see that you've been a victim of domestic violence. I can visibly see that you've got fresh cuts and bruises and injuries. But unfortunately, most of the time that is not true. Many times the injuries are hidden. We do not see them. Or many times the injuries have faded. The reality is that we have to, very well may never know if they were a victim of domestic violence unless we ask. We have to ask them, and we have to ask them the right questions so that we may know if we're providing the right legal services. So, as a divorce attorney, when you have a prospective client in front of you that you find out has been abused, or any prospective client that's a woman actually, you really have 4 different options. Option number 1 is to represent them. Represent them in both their divorce and their injury claim. You can represent them in both. Now we'll talk about more about that in a minute. Option number 2, you could do only the divorce and then refer out the injury claim to another attorney. Option number 3 is you could decide to refer both the divorce and the injury claim out to another attorney. Or option number 4, you could decide to only represent them in the divorce but completely ignore and not ask them about the injury claim. Now, 3 of these are viable options and 1 of them is not. So let's talk about the option that's not viable, number 4, in which you represent them in the divorce but ignore or fail to ask them about the possible injury claims. So what is the danger of ignoring the personal injury claim, not asking about it? You are risking huge malpractice liability. It's my own personal prediction that I believe that this is going to be a greatly increasing situation in the near future, and you're going to see a whole lot more of legal malpractice cases arising out of situations where attorneys fail to represent or help their divorce injury clients. So why do I say that? Well, the truth is you already know this. This is a very, very basic legal principle taught in all law schools. The standard first-year curriculum for law schools will all include the 5 basic subjects: the civil procedure, contracts, criminal law, property, and torts. It's one of the basics at every law school. And so the chances are that in your very first semester of law school, in your first 3 weeks of law school, you were working on a domestic torts outline. And the very first thing that you learned is that one person cannot haul off and hit another person. That's an assault or battery, and you cannot do that. That is a tort that everybody goes through learning about in law school, and learned it within the first couple weeks of law school. Not only that, but every practicing attorney has to pass the bar, and they are expected to know this. In order to pass the bar, all lawyers are expected to have a minimal degree of capacity and competence. And one of the things on the multi-state bar exam, there will be 25 questions related to torts. And the most basic question of torts is related to assault and battery cases. So lawyers are expected to know this. And frankly, they do know this. So what's happening here? Lawyers have been failing to inquire. And lawyers do have a duty to inquire. Every state has their own legal ethics laws, but they're usually based on the American Bar Association Model Rules of Professional Conduct. And Rule 1.1 governs lawyer-client relationships. The lawyer shall provide competent representation, including thoroughness. Now, the comment to the rules clarifies that this includes inquiry into the factual basis of the client's legal problems. So lawyers have a duty to inquire, and they have a duty to keep abreast of the legal changes in the laws. These changes that we're talking about with domestic torts and divorce injury claims, they have been allowed now for well over 20 years in every state of the nation. Lawyers are expected to know this. Now, there's also the duty to inform. The ABA Model Rules of Professional Conduct under Rule 1.1, 1.4, of communication states that a lawyer shall explain a matter to the reasonable extent necessary to permit the client to make informed decisions regarding that representation. So in explaining the matter, the lawyer has to give the client sufficient legal information so that the client can make informed decisions intelligently. The guiding principle is that the lawyer has the duty to act in the client's best interest and not the lawyer's best interest, and cannot withhold information simply to serve the lawyer's own interest or convenience. Cannot do it. Lawyers have to inform your client, and failure to do so could be legal malpractice. So let's take a look at what the legal elements of malpractice are. The four standard elements for legal malpractice are: 1, an attorney-client relationship; 2, negligence by an attorney, which can either be a failure to inquire or a failure to inform the client of their legal rights; 3, a financial loss to the client; and 4, the loss was caused by the attorney's negligence. So there are a couple of cases to keep in mind related to the ethical responsibilities for divorce attorneys to inquire and to inform clients or otherwise be held responsible for legal malpractice. In the 2011 case out of the Idaho Supreme Court, it held that a divorce attorney committed legal malpractice by failing to investigate, inform, and advise the client regarding the legal fair market value of the marital property, and that the attorney's law firm also was liable for the attorney's legal malpractice. Now, this is an important thing to remember. Are other attorneys at your law firm, are they doing this? Are they investigating, informing, and advising the client of their legal rights? If not, it's not just that attorney that might get hit with malpractice, but possibly the law firm as well. Now, the court stated that the client retained the attorney for the purpose of assisting her in her divorce practice, and it's implicitly included assistance with valuation of the marital property, and that the attorney has to make a minimal investigation into the value of the property, into the value of her potential claims. The court also stated that the attorney in the divorce proceedings was also to pursue the most equitable division of the community assets for their client. Another case out of Illinois in 2007 is another divorce malpractice case in which the client alleged legal malpractice, claiming that her divorce attorney failed to recover hundreds of thousands of dollars in claims that, had she been informed of, she could have made against her ex-husband. But she entered into the divorce settlement agreement without knowing it. She argued that her attorney had wrongly informed her that she couldn't go after these claims, and failed to inform her of her rights, and failed to conduct sufficient discovery. She alleged that the negligent misrepresentation did not allow her to make an informed decision when she accepted the divorce settlement agreement, and that had her attorney conducted meaningful discovery and informed her of her rights, that she would not have entered into the divorce settlement agreement. Now, the Court of Appeals agreed and reversed and remanded these proceedings. Now, because domestic tort judgments can be so high, a divorce attorney's failure to inquire as to whether a potential client may have been the victim of abuse, or failed to inform the victim of the rights, or how it might impact distribution of property in the divorce, such failure to inquire or to inform can lead to catastrophic legal malpractice claims, especially if the abuser has been criminally convicted and your client suffered severe injuries. So what do I mean by catastrophic? Well, there was a $50 million legal malpractice case that happened in 2019 in Arizona out of a domestic torts claim. Now, admittedly, the facts of this particular case were unusual. In that case, the defendant, abuser, had already been hit with a $50 million domestic tort judgment, and the defense attorney for the abuser failed to address or even advise his client as to their legal rights. The Court of Appeals found that the attorney had justified his decision on the basis that the chances of the defendant ever having any money or was collectible were slim, and the defendant abuser then sued his defense attorney for legal malpractice. The Arizona Court of Appeals held that on these allegations that a finder of fact could determine whether the defendant had been properly advised, whether the defendant would have accepted the settlement, and to what extent the defendant was damaged. So, not surprising, After this Court of Appeals decision came out with this particular ruling, the party settled for an undisclosed amount. That is what catastrophic looks like. This case has since been depublished, but nevertheless should serve as a very real warning as to what catastrophic legal malpractice for failure to inquire or failure to inform in a divorce injury case can look like. So in a legal malpractice case, will a jury accept these excuses by a divorce attorney if they cause the client to lose the value of their domestic tort injury claim by either failing to inquire or failing to inform? So will the jury accept these excuses by the attorney? The attorney says, well, I didn't know domestic violence was a problem that women faced. I didn't know my client had been abused. It's not my responsibility to ask if the client had been abused. I didn't know a victim of assault and battery could sue for their abuser. I didn't know abuse victim's claim could impact divorce property. I'm just a divorce attorney, and I don't practice personal injury. I did not know how much financial value her claim may have. I did not want to tell my client to give them any false hopes. I didn't think the abuse was really that bad. But the defendant is not really criminally convicted. But the defendant's probably not collectible. I don't even know who to refer this case to. So will the jury accept those excuses? Now, you got to think of it almost like an analogy of a primary care physician who finds that something might be cancer. Doesn't the patient have the right to be informed? And what is it that the public or that the jury would expect? And this might be the response that the jury will give you. There's a pretty good chance that's exactly what the jury will think about those excuses. And so I do predict that there's going to be a whole lot more of legal malpractice cases arising out of these fact patterns with divorce attorneys who fail to inquire or inform divorce injury clients. So as a result of these two ethical responsibilities, there are two essential must-dos that attorneys really have to do. One, you have a duty to inquire. Ask every client if they've been abused by their spouse. And you have a duty to inform every client of their potential legal right to sue their abusive spouse and that may affect the amount of property that they receive in their divorce. You must inquire and you must inform. So I have a practice tip for you. So have every client fill out a domestic torts claim assessment form at the first interview. Add this to your documents that you give or that your staff or your paralegals or secretaries give new clients, and ask, have they ever been the victim of an injury by their spouse? This is how you can this is how you can fulfill your duty to inquire. Then, on the same document, inform them of their legal rights, that if they have been abused by their spouse, they may have the legal right to sue their abusive spouse, which may impact the amount of property they receive in the divorce, that their claims may be affected by statutes of limitations, whether you intend to take the case or whether you're going to refer the case. You can also include easy information as to referring this information if you decide not to take it. At the conclusion of the representation, I'm going to give you a link to a sample document that you may download and use, so you can take care of both of these duties, the duty to inquire and the duty to inform, in that one simple form. It's actually easy. And we've got that document for you. You can download it and you can do it. I'll give you that link in just a moment. Now remember, we've talked about 4 different options that you had. And a moment ago, we talked about what not to do, option number 4. Don't ignore it and don't fail to ask about whether your client's been abused. So let's go back to the other viable options of what you can do. Now, number 1 is to represent them both. Do both the divorce and the injury claim. So can you represent the client in both a divorce and an injury claim? Yes, you can. But there's an important key to it. And that key is that you cannot do a divorce on a contingency fee basis. Now, while it may be common billing practice for personal injury attorneys representing a car crash to do it on a contingency fee basis, divorce attorneys cannot do a divorce injury claim on a contingency fee basis. You have to do it on an hourly basis, just like you are already billing anyway. So as long as you're doing the divorce injury claim on an hourly basis, you can represent them both. This is governed by the ABA Model Rule 1.5 that says that in a domestic relations matter, you cannot do a contingency fee. So just do it on an hourly, like you're already doing in the divorce anyway. So you can actually have two separate billable cases for each client. You can have a billable case for them in the divorce, and you can have a separate billable hour for them over in the personal injury case. So why do both the divorce and the personal injury claim? Well, the number one reason is that many clients desperately need it. There's a huge underserved population. Remember, there's 42% of women that have been divorced that will say that domestic violence was a major factor in causing their divorce. The clients need it, and that's the most important reason. However, there is also a huge secondary reason. This creates a huge opportunity for the lawyers. Why? Well, there's a book that came out a few years ago on successfully developing your business. It's called The Blue Ocean Strategy: How to Create Uncontested Market Space and Make Competition Irrelevant. It is a bestseller, revolutionized successful business strategy, and many of you may have already read this book. I highly recommend it. Basically, the theory behind it is that most businesses are caught in the middle of what they call a red ocean, where there's a ton of competition, lots of lawyers, and everybody is fighting, and often spend lots of money and lots of time and effort on advertising just to get the clients to come in because it's kind of a saturated market. If there is ever a red ocean market, it's for lawyers. It's very tough to compete, tough to grow your business, lots of money spent on getting the clients in the door. On the other hand, a blue ocean is discovering fresh areas of practice that often are just outside of where there's already a ton of competition, where there is a blue ocean with very little competition in it, where there are not many lawyers already doing it. There's a lot of attorneys already doing divorce work. Pull up a phone book or Google it and do a search. You'll be able to see many, many divorce attorneys. It's a red ocean full of competition. However, right now, it is nearly impossible to find divorce injury lawyers. There's no advertisements, there's no listings. So really moving from just doing divorce to offering divorce injury legal services is a strong blue market strategy for lawyers. And remember, this is a huge untapped market. 3 million incidents of domestic violence every year, and 42% of women say that domestic violence was a major factor in their divorce. If you're looking to find your niche and grow your law practice, this is a blue ocean opportunity. So I would like to give you some tools and resources that can help you in your practice. Now, regardless of whether or not you choose to represent divorce injury clients, these tools and resources can help you. If you would like to move in and do more in the area of divorce injury law, these tools will really help you. So the biggest problem is, can clients who need a divorce injury attorney even find you? How do you find a divorce injury attorney? Remember, it's been almost impossible for the clients to be able to find divorce injury attorneys. So the first huge resource in your practice is to help clients easily find you. This is groundbreaking, long overdue, and the first of its kind. So we've just launched a brand new website called divorceinjury.com. It is a free legal directory. It is free to the public to use, free for the victims and the prospective clients, and it's also free for the lawyers to join this legal directory. And that's hard to beat, free. We really want to help the victims, thousands of victims of domestic violence and divorce injuries who desperately need these services to be able to find any attorneys who are willing to do this area of law. And so that's what divorceinjury.com does. They'll be able to go to the website, divorceinjury.com, and it's easy to remember. They'll be able to get general information about the legal right to sue their abusive spouse. And then most importantly, they'll be able to click and find a list of attorneys who are willing to do injury claims in their area. If you're willing to do this area of law, you can list your services for free right here. And that will help you be able to get a new market of prospective clients that they'll be able to find you in your services now. If you want to solidify yourself as one of the top, most prominent lawyers in this huge, growing, and untapped market, top priority paid listing options are available to you. These will be in nearly full screen, top priority, first options that prospective clients see when they're doing a search for lawyers in your area. Large space, lots of room for your photo, and give the opportunity to tell your prospective clients why they should choose you. And then with a click, they'll take them directly to your own existing website, kind of like a full page ad in the phone book. And you'll have the first right to renew your top priority placement listing year after year. Kind of like grabbing and keeping the best location on the busiest street corner for everyone to see and know your business. And as we're just now launching this website, top priority placements are still available. So what is the cost for a top priority placement? It's about the same cost as maybe 1 or 2 of your billable hours a month. It's quite low cost marketing to really be able to corner a brand new explosive legal market. You can easily sign up by going to divorceinjury.com and clicking on For Lawyers, or you can scan the QR code, which I will give you shortly, and it'll take you right there. Now, divorceinjury.com really wants to help that 42% of women who say domestic violence was a major factor in causing their divorce. So to help them better get the message, we're going to be reaching out in general messaging campaigns, including social media, to victims in the area to let them know that they have options and they can obtain help, and let them know about divorceinjury.com's free legal directory, where they can find attorneys to whom they can speak about their case and who might be willing to represent them in their divorce injury claims. Now, the primary audience that we're looking at to inform through social media are women that are married, that will be between 20 to 65 years old, living in that particular state where we have attorneys listed on the directory. And this concept can help most those who have a net worth of about $100,000 a month. This is going to be a large audience, and it's going to be able to reach out to them. So let me give you an example of how we're going to try to do this.
Has your spouse intentionally injured you, beat you, hurt you? You may have the legal right to sue your abusive spouse. Divorceinjury.com may help. Some lawyers do divorce, some do personal injury. But until now it has been hard to find an attorney who will do both your divorce and also sue your abusive spouse. This may impact the amount of money your spouse is required to pay you in your divorce. If you have been injured by your spouse, find help at divorceinjury.com.
And we'll also be using social media, which can be especially effective in this particular market. Something like this, simply abused, make him pay, legally, divorceinjury.com, a free legal directory. So this is an easy plug and play nationwide online legal directory with a blue ocean of prospective clients, high value marketing for low cost, or if you prefer, for free as a non-priority listing. We're going to be reaching out to the public through social media outlets, including Facebook, Instagram, YouTube, and etc. We'll leverage the cost benefit of group marketing, increase profitability, because for every one client, there really is the potential for 2 different billable hour cases, one for the divorce and another for the injury claim. And it can lead to better divorce results for your clients with the potential of happier clients. And I'll give you an example of that in a second. And because of this, we're just now launching this legal directory. Top priority paid listing spots are still currently available for each state. Now, there's another resource that you need to know about. It is the legal resource book for practitioners called Domestic Torts, Representing Divorce Injury Clients, published by Thomson West Reuters. It is the #1 law book on the subject of domestic torts. It contains nearly 1,500 cases related to domestic torts that are cited, reviewed, and analyzed, discuss all the different types of causes of action, discuss statute of limitations and exceptions, potential third-party claims, insurance coverage, malpractice issues, patent practice pointers for lawyers, and many other issues. You can find a link to order this book on divorceinjury.com by clicking for lawyers, or you can scan the QR code that I'll give you and it'll take you right there. Now, the power of doing both a divorce and injury claim can be dramatic, and it can improve divorce results for your clients right now. Now, why in the world do I say that? Because, let me share this example with you. This is an email that I received from an attorney who participated in one of my CLE seminars. Hello, Keith. I met with you when you recently spoke at a CLE. I had a mediation the next day and mentioned that my client had been assaulted and received 2 black eyes. We were able to negotiate that injury into approximately $25,000 of benefit to her, and she was happy. This was a big help to me and got me thinking about this issue in other cases. Thank you for your help. That was simply from attending the seminar and using these principles one day later in mediation to obtain a $25,000 benefit for their client, just for understanding the principles. For those attorneys who decide that they still do not want to represent divorce injury claims, the website divorceinjury.com can still help you. At a bare minimum, you now have a resource of where you can refer clients who need these services. No longer is there an excuse, well, I don't know who to refer these cases to. Now you can refer your victims over to divorceinjury.com, making the referrals easy for you. Now, you can find all of these helpful tools and resources at divorceinjury.com and choose the tab for attorneys. Or if you like, there's that QR code that you can scan that will take you immediately to the web page that can help you. It will show you how you can easily join online our legal directory at divorceinjury.com. You can do it for free, or you can secure your priority paid listings that are still available. I believe that these are going to be absolute gold for the attorneys who decide to jump on those and grab those spots early while they're still available. And I think it's going to end up being one of the best financial investments that a divorce attorney can make right now into building their business. You can also order the #1 book on the subject of domestic torts. And you can also download helpful legal forms to help protect you and help you fulfill your ethical duty to inquire and to inform your clients. Download it for free to use it in all of your cases, whether you're going to be representing divorce injury cases or not. Download it and use it to help protect yourself and prevent from potential malpractice claims. So it really comes down to one simple question. Are you willing to add injury claims to your divorce practice? If yes, then we invite you to come to divorceinjury.com and see how we can help you succeed in your practice. Thank you for attending our CLE today.